Continuing to do business and respecting the fundamental rights of workers everywhere in the world is a matter of dignity, but it is also now a legal obligation. Child labour and forced labour are harsh realities. Yet the law exists and the prohibitions and obligations are clear. It has been almost a century since international law outlawed forced labour. Today, the effective abolition of forced labour and child labour are considered fundamental rights. In practical terms, this means that these rights must be respected all over the world, including in the few countries that have not ratified the conventions. International law, therefore, exists in this area, and it must be applied everywhere. And yet, this law is not sufficiently applied. Why is this? What is the problem? First of all, there is no international labour inspection body responsible for monitoring the application of the conventions in the field and, if necessary, sanctioning employers. Monitoring and sanctions are therefore in the hands of states. However, the latter do not always have the capacity, and sometimes not the will, to enforce the prohibition of child labour and forced labour. As a result, international law is applied too little. What can be done? Legislations are emerging that make ordering companies responsible for what happens throughout their supply chain. A double legal revolution is underway. These legislations are extraterritorially applicable, which means, for example, that it is possible to take a case to a French court of justice for victims abroad. They create an obligation of means. They oblige large companies to be vigilant about the risks of forced labour and child labour in their supply chain. This is a groundswell. More and more developed countries are introducing legislation to this effect. This groundswell leads to the multiplication of two types of legislation: reporting laws, which oblige companies to make public both the risks to which they are exposed and the actions they take, and the so-called due diligence laws, which require companies to implement preventive actions in their supply chains. French law is a good example in this area. The French law known as relating to the duty of vigilance of parent companies and ordering companies, adopted in 2017, is considered a pioneering law, from which several countries are currently drawing inspiration. What does this law say? The duty of vigilance is the obligation of large French companies to carry out reasonable due diligence to prevent risks, not to the companies themselves, but to the environment and people. Here we target, in particular, risks in the area of human rights and health and safety. This due diligence must cover the activities of the companies concerned, but also those of their subsidiaries, subcontractors and suppliers, both in France and abroad. In the event of infringement, the law does provide for sanction mechanisms. A company whose vigilance plan does not comply with the legal requirements may be subject to a compliance injunction, if necessary under a financial penalty. On the other hand, a company may be held liable for an accident or damage suffered by persons in its supply chain and ordered to pay compensation. However, the intent of the law is to prevent rather than to repress. In order to fulfil its primary objective of preventing risks, the law requires that vigilance plans be based on 5 necessary and complementary pillars. It all starts with the identification of risks, which leads to the assessment of supply chain actors. Then comes the time to make the appropriate prevention measures and to create warning mechanisms. Finally, as a process is part of a continuous improvement approach, a monitoring and evaluation system must be put in place. To summarise, the intent of the law is that corporates now have a duty to be proactive. They must be able to justify the methods used in their vigilance plan and to demonstrate their effectiveness. the laws of vigilance and diligence are bound to multiply. In addition to the moral imperative to refuse child labour and forced labour in supply chains, there is now also a legal obligation to act. Companies cannot